Welcome to RealClear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. This week, we deal with property rights and the many ways they can be trampled on and rescued. In the second half of our show, we'll speak with freelance writer and retired MIT professor Robert Kanigal, whose recently released biography, Eyes on the Street, The Life of Jane Jacobs, describes the life, times, and epic battles with a woman who finally got Robert Moses to stop bulldozing New York. Up first, we're pleased to welcome Brian Hodges, principal attorney at the Pacific Legal Foundation. Brian, welcome to the show.
Thank you very much.
Brian, I asked you on because you're involved in some fascinating legal cases that get at the root of how politicians and regulators are essentially running extortion rackets that rob property owners to fund progressive social causes. And before we get into the cases, tell us a bit about the Pacific Legal Foundation and how you work with victims of government overreach.
Well, the Pacific Legal Foundation was founded over 40 years ago in the early 70s in response to what was seen as the growth of liberal nonprofit legal organizations and the success they were having in shaping social policy in the courts. A group of conservative legal thinkers and practitioners decided that conservative and libertarian ideas needed their voice in court, and so did the people who supported them. So Pacific Legal Foundation formed in Sacramento out of a group of lawyers who have been working with then Governor Reagan to advance those issues in the courts. Over the years, we've focused on issues like private property rights, balanced environmental regulations, individual rights, economic liberty.
I understand in that time you and your colleagues have racked up 9 case victories in the U.S. Supreme Court. Is that right?
Yeah, that's correct. We just earlier this year racked up number 8 and 9, and we currently have one more case. These are cases where we directly represent the plaintiffs. We have one more case pending in the United States Supreme Court called Murr v. State of Wisconsin that should be argued next year.
How would you characterize the impact of these victories?
We view our litigation as strategic. We choose the best possible cases we can in order to set precedent in the highest courts that will have the broadest impact on property owners and restricting government across the country.
Of course, the balance of the court shifts right and left over time. What do you see in the years ahead?
It's well recognized that elections have consequences, but the consequences to the court are probably the most pronounced because although presidents can be voted in and out every 4 years, the appointment of a Supreme Court justice is for a lifetime tenure. Currently, there is a vacancy after Justice Scalia passed away, and we're looking over the next 4 to 8 year period at least 2, maybe 3 more vacancies. So this most recent election is probably going to have a significant impact on the court and will set the left-right balance for many years coming.
In terms of the property rights issues that you folks litigate, do you think this is a positive?
Yes, I certainly think it's a positive, and I would hope it would be a positive. The left-leaning justices tend to be pro-government regulation, and associated with that are upholding restrictions on property rights.
So, Brian, take us to West Hollywood, California, which is the case that caught my eye. What's going on there?
A brief backstory. Husband and wife entrepreneurs Sheila and Jonathan Lair Greer decided to invest in some property in West Hollywood. They found 2 old single-family residences and decided to redevelop them into a nice 11-unit condo. But West Hollywood had adopted what they call an inclusionary zoning ordinance. It's basically an affordable housing mandate that says that if you build new housing, you have to either provide units of affordable housing to the public or pay a hefty fee in its place. In this circumstance, that fee was $540,000.
Wow.
which represented a third of the projected profit from the entire development. The Laird Grayers, through their company 616 Croft Avenue LLC, which is what the case is entitled, paid the fee under protest and went ahead and developed the condominium and then sued for what's called an unconstitutional condition. This has been a focus of PLF's work for over 30 years, is this tendency of local governments to use their superior power in the permitting process. You've got to understand, when you own property, even though you have the right to use your property to make an economically viable use of property, government restricts it through the permitting process. And because they have the power to say no, they also have the power to impose conditions on your property. They can say that, for example, you can't, in the most famous case, you can't redevelop your land unless you give us a piece of it. Yeah, that was the Nolan case from the California Coastal Commission, where the Nolans wanted to redevelop a dilapidated, about 800 square foot beachside bungalow in a neighborhood of, large coastal homes, nice coastal homes. And the Coastal Commission said, sure, you can do that, but you have to give us your beach. The U.S. Supreme Court said, absolutely not. That's extortion. It's nothing but extortion unless you, government, can show that the condition you're putting on a permit is necessary to mitigate for some negative impacts, like refocusing stormwater flow onto a neighbor's property. That sort of thing is fine. But if you're just using it as an occasion to basically steal, then it's going to be unconstitutional.
So getting back to the affordable housing mandate, why does a city think punishing people who build houses is going to increase the amount of housing?
I can't really get into their mindset there. I think it's probably because it's the easiest way for it to appear that they are doing something to solve the problem, to adopt a rule that says that we're going to make you pay for this public problem, this pre-existing problem of the lack of affordable housing.
What do you make of the lament of so many cities run by progressive politicians that there's a shortage of so-called affordable housing? And do you see a connection between the land use tax and regulatory hurdles that builders have to clear and the prices of the houses they end up building?
Yeah, there's a direct link, and that's sort of the dirty secret in the overregulation of property, is that land use regulations, these restrictions on development, density restrictions, et cetera, all have a price tag. A recent study out of the Seattle area, which is one of the most expensive housing markets in the country, found that 50% of the median value of homes in Seattle was directly attributable to the cost of regulation. The California legislature also did a study, and they found that a significant portion of the cost of housing was the cost of regulation. So the key to unlock this problem is in the regulators' hands. Roll back on the regulations. For example, in the Laird Grayers case, they took 2 residential units and added 11 units to the housing stock. They were alleviating the problem of the lack of housing. And yet they were hit with this enormous fee, a punishment, which is a disincentive. And frankly, they could have avoided that fee by just replacing those 2 units with 2 units and doing nothing to help the problem.
What's the status of the case?
The case is currently pending on a petition for review to the California Supreme Court.
So how long do you think it'll be before the Laird Grayers get their money back?
The legal process, we hope, will only take a matter of a couple of years, at which point the Laird Grayers will hopefully be able to make their claim to get their money back.
Brian, you and the Pacific Legal Foundation have been working for 20 years with a property owner in Florida who was denied building permits by a land use agency because he refused their demands to fund the restoration of degraded government wetlands that were miles away. Give us the background on that case.
This case is truly outrageous. About 20 years ago, Coy Kuntz Sr. purchased an investment property that was zoned for commercial development, located at the intersection of 2 major highways in Orlando, Florida. And The property is located next to a drainage ditch that the government put in order to dewater the property. There's an easement that runs through it with power lines that leaves the property completely barren of any wetlands. When he went and filed his permit applications just to clear the property to prepare it for development, the local permitting agency that was called the St. John River Water Management District, I'll just call them the district, said, no, you can't use that property unless you give us over 90% of your property. That would have made the commercial development impossible. So he asked for alternatives. The only alternative available was for him to go out onto already degraded wetlands that the state owned miles away from his site and pay for them to be restored.
So this was a straight extortion play.
It was. It was pay to play in its most obvious form.
Now, you took this all the way to the U.S. Supreme Court. How did they rule?
The U.S. Supreme Court ruled in Kuntz's favor on the issue whether a demand made in the form of money, which is what the water district did with Kuntz, instead of a demand for property, because prior to the Kuntz case, the Supreme Court had only talked about those cases where the government demands that you give up a portion of your property. The government in Florida had argued that a demand for money is not subject to any constitutional limitation, which is exactly what 5 justices of the U.S. Supreme Court rejected. They said it's clear, it's the functional equivalent of the demand for land.
So that set a precedent.
Yes, that set a precedent, and that precedent is essential to the Laird-Grayers case. That was the case that said that demands for money must be subject to the same rules that show some reason. You can't just use the permit process to demand money or property unless it specifically goes toward mitigating for some impact of the development.
But once the Supreme Court ruled for the Kuntzes, why weren't they immediately allowed to proceed building on their property?
Well, the Kuntz's case is a bit complicated by the amount of time that it took to get justice. Mr. Kuntz Sr. passed away. We litigated the case on behalf of his estate. Because the case was pending and the property was not able to be developed, the Kuntz family eventually sold the property to somebody else who could hold the property while the case was being resolved. Even after we got the U.S. Supreme Court decision, the Florida government continued to argue that even though they lost, they won. They were trying to argue that even though they're not allowed to make that demand for money as a condition of his permit, that the 20-some years he was not allowed to develop his land did not constitute a taking. Therefore, they didn't have to pay him for that period of time that the land laid fallow.
I understand the case was resolved early this year when the Florida Supreme Court denied the government's petition for review. Will the Kuntzes ever collect damages?
Yes. The Florida court has ordered the district to pay damages for a taking for the period of time that the property was not allowed to be developed, and also that they are going to have to pay attorney's fees for all of the effort that the Kuntz family had to go through.
Of course, this doesn't bring the poor man back from the grave, but I guess his heirs will benefit from it.
You know, that's probably the greatest gift you can give to somebody's memory, and the fact that he fought for that long, he deserved this.
So, Brian, how common is it for municipal authorities to try to extort money and land from builders to fund pet projects?
Unfortunately, it's very common. The permit process, like I said earlier, is almost like catnip to these bureaucrats. Because they have you at their mercy, they can make any sort of demand. How I commonly see it is in the context of, say, critical area buffers, where the government says that you can use your land, but only if you give us a third of it and set it aside in a conservation easement in order to benefit some environmental interest. You will also see it with recreational trails. You see it very frequently with affordable housing fees. And one of the problems is that the well-funded developers are able to pay this graft in order to get their developments through. It's the small developers that really pay the cost. And actually, it's not even the small developers. It's the small developers are bearing the burden, and it's driving down their ability to develop new homes. It's the new homeowners that are paying the cost because the developers don't pay it.
If the programs and amenities bureaucrats want to finance enjoy widespread support amongst voters, why doesn't government just tax voters to pay for them?
That would be the constitutional way of achieving change. One of the most famous early takings cases, Pennsylvania coal, in the 1920s, Justice Holmes said that a strong public desire to achieve some public goal or the well-being of society cannot be achieved by taking a shorter cut than the Constitution allows. So when you want to do something like achieve more affordable housing, which is a great goal, that is a crisis for everybody, you can't do it by just forcing developers to pay or forcing individuals to pay for it. If you're going to set that as your public goal, you need to make society at large pay, which would be a tax.
Now, you mentioned how the larger builders and real estate developers accommodate to this. I mean, many of them exist in symbiosis with local politicians. They use campaign donations to grease the skids for relief, and they often get it. What long-term impact does this have on the smaller builders that like to do infill projects and people who are trying to revitalize portions of the city that the big guys aren't pursuing?
Well, the Laird-Grayers case is a perfect example of your question. They were doing infill development, and that's the sort of development that we really need in order to address affordable housing in dense urban areas like the West Coast, where housing costs are out of control. You know, it's not so much that the big developers are benefiting from this program. It's just that they have the ability to pencil out these kinds of fees. It's the small developers, the mom and pops, and the individual owners that don't have that ability. You can't get a loan for these sort of impact fees. You have to pay them out of pocket. So it can kill projects. Large developers, by and large, are not going to invest in small infill projects. So we need to do our best to make sure that those occur, which would be through getting rid of these kinds of truly devastating fees.
Would legislation that created some sort of lower bound on the size of projects that bureaucrats could use to extort money help the problem?
If it was faithfully applied, it could help. The city of West Hollywood appeared to have that, but it was not enforced in this case. It was odd because the city of West Hollywood's affordable housing ordinance was only supposed to apply if they added more than 10 net units. Here, they only added 9. It was an 11-unit development. They were replacing 2, so the ordinance should have never applied in the first place. Also, the ordinance contains a requirement that the fee be related to the impact, and that wasn't applied either.
Wow. So they weren't even following their own laws.
No.
You know, reading these case studies is like getting caught in a Kafka novel where there's no way out. You wonder how much of this goes on every day that never comes to the attention of public interest law firms. It's just life as usual, and these people disappear under the waves. Brian, the country just elected a president who made his career building casinos in corrupt jurisdictions like Atlantic City. He's been on the buy side of political favors his whole career, so he surely knows how the system works. In fact, he bragged about it. Do you see any hope for change now that he's on the political favor sell side?
I don't have any predictions. If there's one thing about this election cycle that I can say is that traditional measures for predicting outcomes just don't work. So I am in the wait and see mode with this one.
I guess his impact will be mostly felt through his Supreme Court nominations.
Yes. And to me, that was the one critical issue in this election, was that whoever becomes president is going to have the potential to appoint justices for 3 seats, which is going to be quite the swing in the Supreme Court for quite a long time. And that's going to set an amazing amount of policy for us going forward into the future.
Well, Brian, we appreciate you coming on the program and describing these cases for us. Keep up the good work.
Thank you very much.
That was Brian Hodges, Principal Attorney at the Pacific Legal Foundation, here on RealClear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. RealClear Radio Hour is a not-for-profit, donor-supported program produced in conjunction with RealClear Politics, America's premier independent political website. To catch up on our past shows, stop by realclearradio.org and check out our podcast archive of over 300 interviews covering subjects as diverse as free-range parenting, big science corruption, community policing, criminal justice reform, fractured feminism, campus injustice, Socratic teaching, crony capitalism, ballooning entitlement debt, free speech criminalization, monetary policy madness, misunderstood math geniuses, police misconduct, poverty alleviation, Greek diners, class action abuse, endangered fishermen, drug prohibition, and the promise and perils of the gig economy. Today's program is partially underwritten by the generous support of Donors Trust, a donor-advised fund committed to promoting a free society. For more information, visit donorstrust.org. Ahead, we'll speak with Robert Canigal, author of Eyes on the Street, The Life of Jane Jacobs, to talk about the remarkable woman who stood up to City Hall. Stay tuned.